Hello. Welcome to Crime in Court. My name is Heather, and this is an update in the Delphi case that we've been following regarding the unalivings of Abby Williams and Liberty German, and also the charges against Richard Allen. We're following those as well, who has been charged for the crimes. At this point, though, he's only been charged with the abduction, I believe, and kidnapping, not the unalivings, but I believe those charges are going to be coming if they haven't already dropped. So this video we're going to talk about, because there have been so many motions that have been going on this week, and I've already done a couple videos this week. Normally I like to reserve it for the end of the week and put it all together, but there were just too many stories this week, so we're going to, or not stories, but filings, so it made for multiple videos. We also have a third Frank's motion, which I'm not going to read in this video. We're going to do that in another video as well, so just be aware there's a lot coming still. But where we are right now, there is going to be a hearing Monday the 18th of March, and it's closed doors. It's probably going to be in camera, which means actually no camera. You're going to be in like in the judge's chambers and have have an on the record conversation potentially. That's what I think might happen, because that's what she did to kick him off the case last time, and I'm not so sure that she's not going to try to do that again this time, but we'll talk about that in a second. Before we really dive into all these motions, we're going to go through a bunch of different motions, and then at the very end we're going to talk about Geofence data, which was mentioned in a previous motion that was made public this week, which we did in another video. So we'll talk about that, and don't worry, you don't need to have seen the other video about that motion to understand. We'll just dive right into the geofencing stuff. But first, I do want to make a public service announcement. So I want to thank all of you, my followers, subscribers, viewers, all of you who are here watching now. Thank you so much. Thank you for your positive feedback, your support for helping my channel. I really appreciate it. I'm just, excited to be doing this, and I really love talking about true crime, and that's why I'm here. So, to kind of piggyback off of that, there's been some vitriol in the comments, and I just want to say, I don't allow insults. I don't allow rude, insulting comments. If you're going to be partaking in my channel, whether it's watching, viewing, subscribing, however you do it, commenting, I just want a positive, safe environment for all of us. That includes me, myself, the person who is running the channel, and also all of the people that are commenting. So if there are people that are going to be here basically just to argue or to insult others, then they will be blocked and reported to YouTube. I really want like a positive, cordial environment for all of us, a safe environment for all of us to talk, regardless of your views. You can disagree with my view. I don't care about that. Tell me why. Have a discussion about why you disagree with me. Don't come at me and say, well, you're wrong and you're annoying and, all those other things that people say. So let's just try to be kind to one another. Kind words. Use kind words. If you want to be mean about the subject of, the content of my video, that's fine. The people that I'm discussing in the video, if you have something not so nice to say about them, whatever, I don't care. But don't come after myself or my subscribers, followers, my engaged, interacting people. So please, thank you. Let's keep it cordial, and that's all I'm going to say about that. So moving on. So the first notice that we're going to, or filing that we're going to look at, is the notice of discovery. Like I said, some of these are just really short. So comes now the defendant by counsel Bradley A. Rosie and notifies the court that on or about March 14th, 2024, Attorney Rosie provided the following discovery to the state of Indiana, and he turned over Richard Allen's medical records part 1 and 2 from Westville Correctional Facility. So what this tells me is that there might be a lot of records to go through. One, because there's 2 parts, and 2, because well, it's interesting because Wabash Correctional Facility isn't on here. This is just Westville. So I don't know if they would turn over Wabash as well. I don't know why, if they were willing to just turn medical records over or what. I don't, usually you're kind of afraid to do that, and they haven't put in some kind of insanity plea or anything like that. So it's not like his mental health is in question right now at this point, although they argued that it was, but the state argued that it was relevant for them. Anyways, all right, so defendant's notice of submission of supplemental witness list to the state comes now the defendant Richard M. Allen by counsel Bradley A. Rosie and respectfully notifies the court that the defense has turned over a supplemental witness list to the state outlining the witnesses that the defense may call at trial. The defense may supplement the list of new witnesses if new witnesses are obtained. So basically, this is just putting it on the record. We turned over our witness list to the state. So they have that now. This is interesting. List of additional witnesses comes now counsel for defense counsel. So this is David Hennessy for Baldwin and Rosie. Notifies the state and the court that he intends to call Richard Snay during the contempt hearing. Okay, so David Hennessy is going to call this Richard Snay at Monday's hearing. So if you're watching this today, it's tomorrow's hearing because I'm putting this out now, right away. So, all right, so counsel first learned of the substance and importance of Mr. Snay's testimony on March 14th. So let me just take a look at the calendar here. 14th was Thursday. And at this point, the defense had already put in a ton of different orders, some requesting, a continuance, some requesting Nick McClelland and Judge Gull to recuse themselves. So they put out a ton of different filings, and we have not heard one response from the judge regarding the filings, except other than she put out on Friday a decorum notice what her courtroom decorum rules are going to be, which they didn't seem anything out of the ordinary. So I don't know, but I guess that's her answer, is we are going forward and I'm still the presiding judge. I don't know. So anyways, this Mr. Snay, they weren't notified of him until the 14th, or at least of his importance to the testimony, when he returned a call as requested in a voicemail. Notice is being given the same day. So we just found out about this Richard Snay guy because he just called us. We just got some juicy bits of information, and we're going to call him. And we're notifying you right now because we just learned this. So that's just themselves protecting the record. All right, so this is a verified supplement to the verified emergency motion for continuance. So we read that in a previous video. They asked for a continuance because this is all unimportant when it comes to the trial for justice for Abby and Libby, and potentially Richard Allen too. He if he is innocent, he deserves justice as well. So we need to go forward with trial rather than all this ancillary stuff, which is why they put this motion in to just set this aside until the trial, because we have a speedy trial date coming up. So it is May 13th. We're going to begin trial, and that's not very far from today. So it's going to fly by, especially for those attorneys, and we're dealing with all this. So they might not be quite prepared, and it might be, the state's strategy. I don't know. What do you guys think? Maybe it's the state's strategy to make them not ready, but then the state's not going to be ready either. So I don't know. All right, so anyways, the verified supplement to verified emergency motion for continuance comes now counsel for defense counsel. So again, this is Hennessy saying, for the above described supplement states, the prosecution provided additional discovery on March 14th, 2024, which consists of 14 megabytes of screenshots and photographs. So yeah, I definitely think the state is playing games. Hey, we have a hearing for your contempt coming up in 2 business days. Here's 14 megabytes of screenshots and photographs for you to go through to distract you from preparing for that hearing. I totally think it's a strategy to really derail, I guess what I'm saying, to derail the defense's momentum going forward through the Richard Allen trial. All right, so they ask counsel for defense counsel again respectively praise the court to continue the March 18th contempt proceedings. So this is like the third, fourth time they're asking. It's they've asked multiple times now, and all we know is that the judge moved forward with putting out her decorum rules as an answer, basically stating, I'm not going to answer you in a deny minute order like I always do, but I'm going to answer you by saying, here, this is how you better behave in my courtroom. Anyways, so this is the memorandum concerning contempt proceedings. And this is interesting. I really love that they put this on the record. Hold on, I want to go down. I like to see who signed it. Okay, so this is David Hennessy. I can't remember who this was from. So this is David Hennessy. So counsel for defense counsel, again. And this is really a great way because I think because the hearing on Monday is not going to be on camera. We're not going to have any access to it whatsoever. Maybe we'll get a transcript in the future, perhaps, but I'm not totally kill him. My boyfriend's vacuuming while I'm recording. Sorry guys, I'm going with it. This is like the 4th or 5th take because I'm having issues. I'm just going with it. So anyways. Oh my God. Hold on one second. All right, I am so sorry. Oh no, my screen's all crooked. I apologize. I'm trying to get all situated now. That was That derailed me. Okay, so I think this is all to derail Baldwin and Rosie, but here we are. And now this, like I was saying, this is a memo from David Hennessy, and I love that they did this in order to get some things out there to the public prior to the hearing, because the hearing is not going to be on camera. So this is for, I think it's for us to read and not necessarily for the judge. It is, I mean, it's for the judge, but I think it's also for the public. I think this was a good PR move. So, memorandum concerning contempt proceedings. Undersigned counsel incorporates herein by reference, as if fully set out, Professor Osbrook's pleading titled Defendant's Counsel's Motion for Summary Denial of the State's Verified Information for Contemptuous Conduct. And we went through this in an earlier video as well. This was more about, you know, that the proceedings should have been done separately. It's not supposed to be under Richard Allen's case file. It's supposed to be under its own separate filing, and it's supposed to be, you know, is it criminal or is it, the other words, blanking, I'm blanking right now, but what kind of proceedings would we go for, is what they're, I don't know. Anyways, never mind. So derailed from my boyfriend. I can't believe you just did that. Anyways, undersigned counsel incorporates herein by reference, as if fully set out, Professor Osbrook's pleading titled Defendant Counsel's Motion for Summary Denial. Sorry, I read that. Okay. So press release. The gag order was issued on December 2nd, 2022, and states explicitly that it was issued in response to the defense press release from December 1st, 2022. So the press release went out on the 1st, and the gag order was issued on the 2nd. Thus, the press release could not have violated an order that was issued the very next day. You can't violate something that's not there until the future. All right, so to the extent that the press release may have violated a rule of professional conduct, trial courts are without jurisdiction to enforce those rules to determine attorney misconduct. So Judge Gold does not have the authority or jurisdiction to enforce any certain rules on attorneys for misconduct. All right, so the Indiana Constitution grants exclusive jurisdiction over attorney disciplinary matters to the Indiana Supreme Court, not the trial judge of the defendant's, the defendant. Yeah, it's supposed to go to the Supreme Court here. Imposing attorney discipline and protecting a defendant's constitutional rights are separate matters. Little versus State. This court has repeatedly declined to step outside its jurisdiction and act as a disciplinary body to determine whether an attorney's actions are unethical. Bennett versus NSR Inc., refusing to address whether an attorney's conduct is unethical. In Carter versus Knox County Office of Family and Children, concluding that a trial judge's violations of the Code of Judicial Conduct was not proper consideration for the court. So the preamble of the rules provides, in relevant part, violation of a rule should not itself rise to a cause of action against a lawyer. So just because they may have violated a rule, even if it was unintentional and not done on their own volition, like these photo leaks, it's not, you're not just to presume that the lawyer was breaching their duty. So in addition, violation of a rule does not necessarily warrant any other non-disciplinary remedy, such as disqualification of a lawyer in pending litigation. The rules are designed to provide guidance to lawyers and to provide a structure for regulating conduct through disciplinary agencies. They are not designed to be a basis for civil liability, but the rules may be used as non-conclusive evidence that a lawyer has breached a duty owed to a client. Furthermore, the purpose of the rules can be subverted when they are invoked by imposing parties as procedural weapons. So you're not supposed to be using these rules just to, you're not supposed to weaponize these statutes, these rules, just for your own benefit. And especially, if Nick wants these guys off the case, or if he doesn't like them, he's got some kind of grudge against them, he doesn't like their defense strategy, whatever it is, it seems like he's coming at them like retaliation. So this is exactly what the statutes say you're not supposed to do. The fact that a rule is just basis for a lawyer's self-assessment or for sanctioning a lawyer under the administration of a disciplinary authority does not imply that an antagonist in a collateral proceeding or transaction has standing to seek enforcement of the rule. Alrighty. And that was the Indiana Professional Conduct Preamble. Alright, so accidentally misdirected email. Attorneys Baldwin and Rosie have fully explained how this happened. It clearly was not knowing, intentional, or willful. The law regarding indirect contempt just as clearly requires willful conduct. Accidental misdirection is a common occurrence for anyone that uses emails daily. Yeah, I mean, it's happened to me countless times. I don't know, like you put in MI for Michelle and Michael comes up or whatever, I mean, it happens all the time where you type the first two words and then the autofill does the next or does the last person that you emailed that's starting with those letters. So it happens to the best of us. And it happened to Andrew Baldwin, and it wasn't anything that needed to be of such great concern that it was leaked to him. Anyways, he'll explain it better than I can. So the prosecutor in this case acknowledges the possibility of accidentally misdirected email at the bottom of his emails. So Nick McClelland, the person who is saying that it was misconduct for Andrew Baldwin to accidentally misdirect an email to someone, actually has, like most lawyers do, a little tagline under their signature saying, if you get this accident by email, please delete. This is not for your eyes, type of thing. And he has one at the bottom of his email, Nick McClelland. So it is because people are human and humans error. And that is just what it is. Even though it was the computer who did the autofill, but I digress. All right, so most, if not all, users that experience such follow-up requesting that it be deleted after learning it was sent to an unintended recipient. So a lot of lawyers have that. Additionally, the only thing related to this case that was sent was a defense-created outline organizing their own discovery. It describes the discovery, but not the contents of any discovery. To the extent it contained the first names of the victims, it was intended for internal use only. Furthermore, their first names were used publicly by agents of the state from day one and incessantly after. There you go. Contrary to the prosecutor's allegation, the accidentally misdirected email did not violate the court's gag order. The order specifically applied to, quote, means of public communication, end quote. The email at issue was private and sent to a single individual. Attorneys Baldwin and Rosie had no reason to suspect further dissemination by the unintended recipient. And if that did happen, they certainly had no prior knowledge of such and did not condone it. So it was not willful. They didn't mean to do it. It wasn't even that big of a deal. Let's move on from this. Lastly, the February 17th, 2023 court order referenced by the prosecution cannot logically or realistically apply to an email sent in December 2022. Good point. All right, so candor towards the tribunal. Mr. McClelland has shared that it is his position that Mr. Baldwin was somehow required to voluntarily and immediately report the accidentally misdirected email to him and the court. He has not provided any authority for such a requirement, and the defense can find none. So he's mad. McClelland's mad because Baldwin and Rosie didn't report it to the court right away. At least Baldwin, because it was his misdirected email. He didn't report it to the court immediately, but they're saying there's no such requirement that exists for them to do so. No such requirement is contained in Rule 3.3 of the Indiana Rules of Professional Conduct. The rule prohibits making a false statement or failing to correct a false statement. Mr. Baldwin did neither. The rule also prohibits the failure to disclose legal authority known to be adverse, quote, to the position of the client, end quote. Mr. Baldwin has not done that. Lastly, the rule prohibits a lawyer from offering evidence known to be false. Mr. Baldwin has not done that. So, yeah. I don't know. What do you guys think? Would a misdirected email would that rise to misconduct in your companies where you work? Probably not. I mean, even if it was a confidential file, I mean, would you be punished for something like that? Probably not. All right, so the commentary to the rule makes it clear that a lawyer has no duty to report such information, but only to ensure that the tribunal was not misled. Consequently, quote, consequently, although a lawyer in an adversary proceeding is not required to present an impartial exposition of the law or to vouch for the evidence submitted in a cause, the lawyer must not allow the tribunal to be misled by false statements of law or fact or evidence that the lawyer knows to be false. Mr. Baldwin was forthright and complete in his communications with the court about the email sent to an unintended recipient. Also, it is clear from the body of the email that it was addressed to Brad, not Brandon. So as you can see, B-R-A-B-R-A-N-D, I mean, he probably emailed Brandon first and it popped up in his autofill. All right, so Mr. Baldwin has not violated the rule, so it cannot constitute contemptuous conduct. The leak. Quote unquote leak. The leak complained of cannot be laid at the feet of defense counsel. It is beyond cavil that they did not provide any part of discovery by photographs or otherwise to anyone outside the defense team, nor did they knowingly or intentionally allow anyone access to discovery materials. Mr. Holman refers to Mr. Baldwin as a victim in his report of his investigation of the Westerman leak. Detective Rector swore in an affidavit for the prosecution of Mr. Westerman, that's the guy who leaked he was his friend, who snuck behind his back and took some photos and leaked them. So Detective Rector swore in an affidavit for the prosecution of Mr. Westerman that Westerman photographed discovery items without permission or authority. This is just victim blaming by the prosecution because it does not like the victim. Again, you're just coming at us because you don't like us. You want us gone. Furthermore, there was nothing in the dissemination by Westerman that would not eventually become public, meaning that even the files with the, crime scene photos, autopsy photos, all of that can be made public at the trial. It's not like it's necessarily going to be published anywhere, but it's still public information. And technically, it's not, it wasn't under a gag at the moment. Oh no, well that was, the photos were, but at that point. But anyways, yeah, so they are victim blaming. It's like a good excuse to blame Baldwin for something that they don't like. It is possible to tell exactly what information on the internet came from where. The leaks have been prevalent and consistent from the outset. With regard to the Westerman leak, it is not known how many pictures he took of what. There have been a variety of descriptions as to just what he sent to Fortson. The first leak about the case came from the search team shortly after the unalivings, according to the sworn testimony of Jerry Holman. The next came from Mr. Holman himself, according to Terry Williams. So the leaks are not coming from the defense, is what they're saying. There have been prior leaks that we had not, I mean, they were happening before we even came on the case. The leaks escalated after the arrest of a suspect. There were 2 probable cause affidavits leaked before they were publicly available. There was a leak of information about a bullet at the crime scene and a gun at Mr. Allen's house. Gary Baudet, aka Fig Solve, published these leaks on November 22nd, 2022. He claimed that his source was an employee of Judge Gull. And there you have it. I mean, I'm not saying that this is necessarily true in fact, but let's see what he has to say about that. Baudet references this video in a Discord chat session on April 2nd, 2023 as proof that his source, quote, works with the judge, end quote, and that he had the Richard Allen probable cause affidavit a week before the document was unsealed and made public. He has said that he knew the defense attorneys would be disqualified a week before they were, and that it was a win. So this personality, I'm not sure who they are. Maybe it's a YouTube channel or they have a podcast or something. I don't know. But they have some sort of platform where they have been able to reference videos and whatnot. And he's got a Discord chat. So that's all I know about this Gary Baudet. But it seems that he's getting information from an insider of Judge Gull's. Interesting, huh? So there were leaks before attorneys Baldwin and Rosie were appointed. On May 17th, 2023, Fox 50 reported on facts contained in a probable cause affidavit for the search of Ron Logan's residence, filed March 17th, 2023. Defense counsel had no access to that document. So, yeah. There was information about Ron Logan's residence that was leaked. And defense didn't even have information on that. So there's no way they did it. Only law enforcement and court staff had that info. So take a look at yourselves, because we're not doing these leaks. On September 29th, 2022, an email was sent from Tony Liggett, and that's the sheriff, to Debbie Lowe of Carroll County Comet. So I'm assuming that's a paper or online something or other, concerning the special prosecutor investigation into Hatch Act violations. This final decision was under seal, and the case is still currently either blocked or sealed from public view. On Gary Baudet doing a live show about Richard Allen's arrest, he mentions that there will be evidence involving a bullet or a casing as part of the probable cause. How does he know that? Baudet references this video in a Discord chat session on April 2nd, 2023 as proof that his source works with the judge, and that he had the Richard Allen PCA a week before the document was utilized. How's he getting that information? On November 22nd, 2022, Gary Baudet, who had communications with the prosecutor doing a live show about Richard Allen's arrest, mentioned that there will be evidence involving a bullet or a casing as part of the probable cause. Baudet references this video, April 22nd, as proof that works with the judge, and same thing. Okay, and that he had the PCA a week before. So they're just kind of repeating themselves. Attorneys Baldwin and Rosie were not appointed yet. So these were multiple leaks that happened. Barbara McDonald had a stick drawing photograph of the tree and Professor Turco's report. So Professor Turco is the Purdue professor that the state couldn't find for whatever reason, and they couldn't remember who it was. They had no info, and this person just magically disappeared into thin air. But then the defense puts out the Frank memo pointing out that the prosecution just forgot who this person was, and then we get the professor. So it's just ridiculous. They basically then interview the professor the next chance they get so that they could put on record that they interviewed him. Barbara McDonald had a stick drawing, a photograph of the tree, and Professor Turco's report that could not have come from or be connected to the defense. So the defense didn't have that. Where did it come from? Neither the Indiana State Police nor the Carroll County Prosecutor's Office have investigated the unrelated leaks. They only steadfastly targeted defense counsel. Any findings of contempt will be contrary to the facts and law and will surely be reversed on appeal. So there are some reasons why this whole thing is bogus. This hearing is bogus, Judge. We want to put this on the record. This is where the leaks are coming from. We're not responsible, and everything else is just baloney. And it's just a smoke show to make everybody look this way while we're hiding the fact that we're covering up some unalivings of some teen girls. Sick. It's really sick. All right, so this is the Geofence data, and I am going to publicly thank Sleuthy Goosey for putting this together. And I found it on Reddit. She posted it. This is a little visual aid that'll help us to understand what the defense is talking about in this motion. And I'll read through these 8 through 11 here, I think. Or 12. All right. So there is new information that supports the defense request for Frank's hearing regarding this geofencing data. Specifically, the defense received certain geofencing evidence that at least 3 persons were in or around the crime scene at a time while the unalivings were taking place, according to law enforcement timelines, and none of the owners of the phones have any connection to Richard Allen. And this is going to be the same for all that I'm going to read through, so I'm probably not going to repeat that. But so according to law enforcement timeline, this is what we're going off of. There's 3 separate phones that were in or around the crime scene, and they are not Richard Allen's or connected to him in any way. Number 9, the geofencing evidence would provide evidence of any of the following scenarios. So these are the scenarios that we're going to kind of walk through. A, those persons walking with the phones are witnesses that would have observed the unalivings as they were taking place, and none of them have identified Richard Allen. So that's a possibility that Richard Allen did it, and none of these people who were walking around saw him. That makes no sense, though. And B, these persons walking with the phones were witnesses who observed nothing, as the unalivings did not take place during the afternoon of February 13th, but the victims were taken to the crime scene after the search was called off. So that's a possibility, that these people were walking around freely and willy-nilly because nothing was happening at that moment. They could be innocent bystanders, or they could actually be, C, those persons walking with the phones were participants in the unalivings. So those 3 people could have been the people, or suspects, that should be sitting in prison and not Richard Allen. All right, so 10, said geofencing, that is small for you guys probably, but it's like blurry if I do, sorry, I should make it big for you guys. So you can see it, but it's blurry for me. All right. So said geofencing evidence was so important to somebody involved in the investigation that they created a map and plotted the movements of those persons, including movements that show that at least one of those persons was within 60 to 100 yards of the crime scene at the time while the unalivings would have been committed. According to law enforcement timelines, the phones once again had no connection to Richard Allen. 11. Furthermore, the map shows that the other 2 phones, as the persons and the persons carrying those phones were in and around the crime scene between 12:39 and 5:49 p.m. on February 13th. The defense has sought out but has not provided any documents or reports that contradict or refutes said geofencing evidence, but have not found such evidence, nor has the prosecution or prosecutor provided any when defense requested reports on said geofencing. So there's reports out there that they don't even have on the geofencing. But so get that, we have multiple scenarios of it could be people walking around that would have observed what had happened, but none of them have identified Alan. It could also be persons walking around that witnessed nothing because nothing happened at the time, or it could be the suspects. So here is the visual that Sleuthy Goosey put together for us. Geofence information, well, for anyone who's interested in this case, 3 persons and 3 phones in or around the crime scene while the unalivings were taking place according to law investigation timeline. There we go, that's better for you. So 2:30 to 3:30 is supposedly when the unalivings themselves were taking place. But these phones were in and around the area for more than just that 1 hour. So we're going to look through. These are our little icons. We have a black phone, which is phone 1, a white and purple phone, which is phone 2, and a blue and black phone, which is phone 3. None of them connected to Richard Allen in any way. So phones 1 and 2 were in and around the crime scene between 12:39 and 5:49 p.m. So that we know. And we know that phone 3 was within 60 to 100 yards of the crime scene while the unalivings were being committed, which according to law enforcement is around 2:30 p.m. So here we have about 12:39 p.m. Then we've got phones 1 and 2 still at 1:39 p.m. They're still there. All right, so phones 1 and 2 could have stayed there, or since the motion, the filing that we read it from, the motion says between those hours of 12:39 and 5:49 or whatever it was. So phones 1 and 2 could have stayed there, or because they use the word between, they could have left and come back. So perhaps they might have left to meet up with phone number 3 is a possibility. Possibility 2, here is possibility 2. They go, so instead of staying around, which is what they're doing here, they're staying around and phone 3 is over here. And possibility 2, they go and meet up with number 3, phone number 3. And here's the high bridge. So maybe they went and met up with the individual who had phone 3. Now, for the 2:30 p.m. to 3:30 p.m. possibilities, all 3 of them could be right there around the area, or they could have been sort of separate, but still in and around at the area, because between 60 to 100 yards versus whatever the other proximity is that they're using. So the phone, where are we? Phone 3 leaves at approximately 3:30 p.m. So phone 3 is gone, and phones 1 and 2 remain at the crime scene until 5:49. What do you think? Could that be maybe Elvis Fields and gosh, I can't remember the other guy's name. And then maybe they were meeting up with Brad Holder. Maybe Brad Holder was phone number 3. They met up with him, or he came to them. Maybe Brad Holder was bridge guy. I don't know. But that could make sense. Like somebody, whoever, phone 3 could be bridge guy. And he could have led the girls down the hill, while he got them down on the lower ground, and then those two other phones maybe met up with them, or he took them to where they were, possibly. I don't know. Or there could have been a potentially third location where they took the girls, and we don't know. So, because we do know that Libby was, some of her BLOOD was drained, or most of it was, I believe. So I don't know. It's and where they found the crime scene wasn't where that happened, so that it was never necessarily confirmed where she might have been drained, because they never went with this angle as the Odinist angle. So it might have just been overlooked. I don't know. Maybe they didn't look for a third spot. Maybe there was someone who lived nearby, and they brought the girls to a house until they were ready to do the ritual that they wanted to do. I don't know, but it makes sense that it didn't happen at 2:30 to 3:30, in my opinion, or these cell phones had something to do with it. That's either or, you know. So, and the fact that the geofencing data for these three phones was not turned over is very suspicious, in my opinion. Makes me think it might have something to do with Elvis Fields and Brad Holt. Well, maybe whoever the unalivers are, it might have something to do. I don't want to like put blame out there, even though it's already been out there in public documents, but I'm not blaming anyone in particular, just so you know. This is just opinion, thoughts, and, spewing theories. So anyways, what are your theories on this case? What do you think happened? Do you think that these cell phone, was this helpful? I thought it was really helpful. But also, what do you think about how the cell phone data, what does this show? What does this geofencing show us? And also, what do you think about these other motions that we've gone through? Let me know in the comments below. I really appreciate you guys for being here. Thank you so much. Take care and stay positive. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeandcourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.